morning, Your Honors, and may it please the Court. I'm Thomas Burns, and I represent Ms. Wagner-Simpson's former counsel. I'd like to reserve 4 minutes for rebuttal, please.
Okay.
This is a novel appeal that raises two neat issues, I think.
We're just full of novel appeals this morning.
I'm glad to hear it. I just got here recently, but those are the best kind of days.
That's great.
The first overarching issue is whether constructive discharge is a basis for enforcing a charging lien. And then the second issue would be, if so, whether Ms. Wagner-Simpson in fact constructively discharged the former counsel. So let's look at both of these issues in turn. And the place to start, as it always is with an appeal, is the order. And the order itself says the court declines, in the absence of legal case law support, to find there was a constructive discharge. So I'd like to draw your attention to that clause in the middle that says, in the absence of legal case law support. So that's the legal issue that the court was determining in the trial court. And that would raise another question, is what is constructive discharge? And constructive discharge, our theory was under the Webb against Florida Health Care Management Corporation case, which is a 4th District case. The standard is an employee must show under an objective standard that the employer made working conditions so difficult that a reasonable person would feel compelled to resign. Now, obviously, that's an employer-employee case. It's not an attorney-client case. But in any case, that's our theory of the case. And the question is that standard something that falls within the rubric of Rosenberg against Levin or Farrow against Romani? And our position is that it is. Under Rosenberg, the case says the attorney is entitled to charging lien if they're discharged without cause. And it doesn't say whether that's an actual discharge or a constructive discharge. It just says discharge without cause. And so our position is that a firing is a firing, whether it's constructive or actual. And
do we need to talk about constructive discharge or to determine whether or not there was a discharge in fact on this record?
Well, I don't think that you're skipping ahead to my second issue, which is totally fine. But I don't think that the court actually determined whether there was a constructive discharge or not, and that's because of the language of the order. The order says the court declines, in the absence of legal case law support, to find there was a constructive discharge. And my reading of that is saying, well, I don't think the law supports this theory, so there's no constructive discharge. Now, if you disagreed, then obviously, if you read that language differently, then that presents a different problem for me, because then that would be a factual finding that the court is saying, well, I believe that there's a constructive discharge theory, but I'm making a factual finding based on this record that there was no constructive discharge. Obviously, that's a more difficult appeal for me to win, but that's not my reading of the order. My reading of the order is the court is saying, well, you're not presenting me with cases that say that this is a viable theory, and therefore I'm not going to find it, which to me is a legal determination, not a factual determination. Ms. Wagner-Simpson responds to this theory and says, well, there's two problems with it. And the first is, nobody's ever done this before. And the second is, well, what you're really saying is you're raising a theory that's synonymous with a breakdown in communication or irreconcilable differences. And then she cites a litany of cases that say, well, that's not sufficient. You know, it's got to be something other than that, because those just aren't good enough. Now, as to the first point, that's right. I've looked extensively for this kind of case in the attorney-client context, both in Florida and throughout the United States. I haven't found it, and I'm sure that my colleagues here have done as well, and they haven't found it either. So you would be, in a sense, breaking some new ground. The second issue is something that we disagree with. We think that this is not synonymous with a breakdown in communications or irreconcilable differences because of the length of time that this went through. Now, you can think of like a breakdown in communications as like something went really wrong in the relationship and you're just not talking for a little while. But at some point, there is a discharge. I mean, whether that point would be 3 months, 6 months, 12 months, whether you can establish a bright line rule, whether it's something that the court is the fact finder is supposed to determine based on some kind of reasonable person standard, which is essentially what the Webb case that I described to you before is doing. Those are all separate questions, but at some point there is a discharge. And I was just thinking about practically what that would be, and if you think of just in terms of human relationships, if you're if you're dating somebody and you keep sending them messages or calling them and they're not returning it, at some point you have to realize that relationship isn't working, that relationship has been ended, and you've been discharged from your duties in that relationship.
Let me ask you a question, that's something that's been bothering me, but I'm not sure where it fits into the argument. Your clients wrote to Ms. Wagner and said, you can discharge us in writing. So they told her, here's how you discharge us. You send us a letter and you tell us. And she never did that. So from her perspective, she hasn't, she's not communicating, but she hasn't discharged them either.
I hadn't thought about it that way. I recognize that could be an issue. My response to that would be, this could be, and I don't know whether this is the case or not because we don't have frankly, a record that could have been developed as fully as it could have been, but this could be a strategic plaintiff, and the strategic plaintiff is thinking, well, I know that the case law is what it is, and as long as I don't actually say you're fired, I don't have to pay 2 attorneys for my contingency if I win. And so that could be the situation. And then if the lawyers are put in this situation, well, we've told her what her rights are, and she's still behaving in this manner, what are we to do? And I think that's how my clients acted. They said, well, we're just going to acknowledge what we believe to be the case, to have already taken place, and we're just going to tell her, you have discharged us, or based on your conduct, you have discharged us. And that's what the subsequent letter is, which is, I believe it's 8 or 9 months after, or no, sorry, it was 8 or 9 months after her last communication, and then I believe 3 or 4 months after that, the letter that you just quoted. So that's our position under Rosenberg, and our position is basically the same under Farrow. If you were to hold that Rosenberg does not envision a constructive discharge theory, we believe we would still win under Farrow, because Farrow says if you are essentially required by ethics to withdraw, then you are entitled to you're entitled to a charging lien. And there, Ms. Wagner-Simpson responds, well, there are some cases that don't hold that say when a lawyer had to withdraw that you weren't entitled to a charging lien. But those cases are different. Those are the Santini and In Re Naturally Beautiful Nails cases. The bankruptcy case obviously is just a persuasive authority rather than binding authority, but in both of those cases it was the lawyer who was responsible for the withdrawal. Both of those cases involve lawyers who jumped ship from one firm to another, informed the client, we have a conflict, I have to withdraw, but I'm putting a charging lien on, and those courts said, well, that doesn't meet Farrow's standard, and that's not surprising because Farrow says if the client's conduct makes the attorney's continued performance of the contract either legally impossible or would cause the attorney to violate an ethical rule, you get a charging lien. And in both of those cases, that was the lawyer's conduct.
Yeah, well, I think you've acknowledged that that it wasn't impossible. So that's correct. That's off the table. So we're looking at it would have been an ethical violation, and if I understand, your ethical violation is you have to withdraw once someone discharges you.
That's correct.
So really, it's really, you got to get that discharge in here somewhere.
Absolutely, and the only way we can get it in is if you acknowledge that constructive discharge is a viable theory within the charging lien legal universe. If you don't agree with that, then we don't get past step 1, and we can't get to step 2, which is where you wanted to start. So that's our
I am having a hard time, and I understand the difficult position that this client placed these lawyers in, but I'm really having a hard time making the distinction between what happened here and the breakdown of communications kind of cases.
Right, and the distinction that I'm drawing is it has to do with the length of time. Those cases, well, let me take them one at a time. Irreconcilable differences is not the situation here, because those involve cases where the lawyer says, usually it's the client says, file this motion, and the lawyer says, that's a frivolous motion, I can't file it, and then there's a big fight, and the lawyer and the client have to go separate ways. That's not what we have here, because there was just no communication. They weren't talking to each other at that point about how to proceed. So the question would be, really, is this the breakdown of communications or a constructive discharge? And I think there, it's just a question of the extent of time that this goes on. If it's just a couple of weeks, a couple of months, maybe not. But if it gets to the point where it's a year, maybe it does. And that's why I think that your appellate remedy would be to say, or could be to say, trial court, we recognize that this constructive discharge is a viable theory. We don't think you made the finding that you could have made based on the record that was established in the trial court. So just you figure it out. Here, this is the standard. You apply the test of Webb against Healthcare Management Corp. And then if there's an appeal from that, there will be an appeal from that. But at that point, the standard review would be quite different. It wouldn't be a legal issue. It would be, your more typical, that would be the abuse of discretion area, where it's like they're applying this basically a reasonable person standard, and then you're looking at that and saying, well, was that an abuse of discretion or not? But at this point, all you really need to say is, or determine in the first instance is this a viable theory or not within these two Florida Supreme Court cases, the Rosenberg and Farrow. I think that's our case. So unless you had further questions, I'll just reserve the rest of my time.
Okay, thank you.
Thank you.
May it please the court, my name is Jessica Darno, and I'm with the law firm of Weekly Schulte Valdez, and I represent the appellee. Rosenberg only applies when a client exercises their right to discharge their attorney. This is a right.
Okay, I think we've acknowledged that this is a constructive discharge, and I guess the question that's being put to us is, do we want to recognize that
Sure.
as something that would fall under Rosenberg? So what I'd like you to discuss is why we would not want to recognize that. Why wouldn't that be a good idea?
This court in DePena versus Cruz expressly stated that it will not expand FARO. There's two enumerated exceptions in FARO for when an attorney withdraws. And in this case, the only evidence we have were the written communication.
I want to talk about Rosenberg and discharge.
Okay.
Why would it be a bad idea for this court to recognize constructive discharge as a theory that falls under Rosenberg?
Sure. Okay, Your Honor. Let's talk about what a constructive discharge is, because obviously it's never been applied in an attorney-client relationship. A constructive discharge is in an employment relationship, and it usually involves situations with harassment, discrimination, intolerable working conditions. And the definition used to define a constructive discharge is when an employer, so in this case we would have the client, makes working conditions so intolerable or difficult, both terms have been used, that a reasonable person would feel compelled to resign. So a reasonable attorney. So now the court is going to have to use this objective reasonable person standard and determine what is a reasonable attorney, which some people would say doesn't exist. But so what is a reasonable attorney, and what are difficult working conditions for an attorney? But we've already established through this court and through several other cases in Kay, DePena, that difficult working conditions are not a basis to be entitled to fees, because by the definition itself of a constructive discharge, it requires a resignation, a withdrawal. So I don't think constructive discharge would be ever applied under Rosenberg, because Rosenberg requires the client to exercise that right. It's an exercise of their right. A constructive discharge, by its very definition, requires an attorney to resign, and they're resigning due to difficult working conditions caused by the client. And I just think that would place an undue burden on clients, first of all, because now how is a client to know what type of conduct they could cause, and all of a sudden their attorney believes that they've been discharged? Now the client has to go out and hire another attorney and is forced to pay two different attorneys' fees. And that is contrary to the public policy of quantum merit. The Carbonic Consultants case makes it clear that the client's interest should come before those of the attorneys, and that's due to the attorney-client relationship. It's very different than any other type of employment relationship. In this case, the appellee The appellee had no contractual obligation to communicate with her counsel. We don't know why she wasn't communicating. There's no evidence submitted by the appellants as to why she was not responding. We only know what her last communication was, and that was, please don't initiate any further action right now, but continue to advise me of any communications that you have with the defendants. That was her last communication to them, and then it was 9 months of silence. However, there was no evidence presented that she even received the letters that the appellants were sending her, because there's no evidence that they were sent certified mail. There's no evidence whatsoever that she went out and retained another attorney. Quite frankly, and it was appellant's burden, it was their burden to establish that she discharged them. And just to talk about the standard of review very quickly, the appellants stated in their initial brief that the issue before the trial court was, did Ms. Wagner discharge the appellants, or did the appellants withdraw? And that would have been a factual question under an abuse of discretion. But I do agree that if this court is inclined to create new law and allow clients to constructively discharge their attorneys, then it would not be an abuse of discretion standard, obviously. But I do believe that creating the constructive discharge in an attorney-client relationship theory would be contrary to Farrow. It would be contrary to this court's ruling in DePena versus Cruz, because I think that it is synonymous with the cases in which clients they're causing difficult situations for their counsel. It's a breakdown in the relationship. And the correspondence from the appellants to Ms. Wagner, they expressed their frustration. They wanted to move the case forward, and she had told them not to do that. That's a difference of opinion. There was a breakdown in their relationship and their communication. And the cases in DePena, in Kay, in Rocha, all of those cases hold that under those circumstances, we're not going to allow the attorney to receive their fee because they withdrew, and there was no ethical obligation for them to withdraw. I think it's undisputed here. There's no ethical rule that states if your client's not communicating to you, then you need to withdraw. There's no ethical rule that states that. So unless the court has any further questions, I will conclude.
Okay, thank you.
Thank you.
I think we'll end early on this one, so that's good. There's really just 2 points that I wanted to make. The first is, Judge Kelly, you were asking, what's the public policy rationale for this? I think the public policy rationale has to do with it's an objective standard, not a subjective standard. In the answer brief, Ms. Wagner-Simpson had taken the position that, well, if it's subjective, then all these lawyers are going to start doing this, but it's going to be protected by the trial courts. The trial court's going to apply this objective standard, and trial courts do that all the time. And that can either be done by the court or whoever the fact finder is going to be. And I think that's consistent with the goals that we're trying to pursue with quantum merit, which are announced in Rosenberg, where they're saying, well, we're trying to split the baby here. We want to protect clients and allow them to jump ship mid-trial without punishing them, but we also want to protect lawyers who get their ship jumped off of. So I think this is an objective test that would protect both sides of this engagement. And then my colleague mentioned again the breakdown in communication and the irreconcilable differences. I just wanted to point out that those are permissive bases for withdrawing. They're not mandatory bases. And my clients understood that they were constructively discharged, and if they were discharged, that was a mandatory basis for withdrawing, and that's why that there was an ethical problem under Farrow that they believed required them to withdraw, but also entitled them to assert a charging lien. So we're asking you to vacate the order, acknowledge that constructive discharge is a viable legal theory, and then remand to the trial court with appropriate instructions to implement that theory.
Thank you.
Thank you.
Thank you both. All right. Next up, we're going to take Galloway versus orthopedic specialists. course.